When a marriage contains a severe legal defect, you might assume it automatically shatters, offering a clean exit for everyone involved. In family law, the reality is more precarious. A flaw doesn't always break the bond. Sometimes it leaves you suspended, and escaping requires a precise execution of legal procedure. In England and Wales, the law splits defective marriages into two distinct categories: void and voidable. The mechanics of how these two operate determine whether you find an exit or a permanent legal trap. We start with a void marriage. This is a union that suffers from a defect so severe that the law treats it as a legal fiction. It is void ab initio, meaning from the very beginning it never existed. Section 11 of the Matrimonial Causes Act 1973 outlines what triggers this. If a person is already married, committing bigamy, or if either party is under 18, or if they are closely related within the prohibited degrees of consanguinity, the state refuses to recognize the marriage. Because a void marriage never happened, you don't strictly need a court order to end it. However, practitioners regularly apply for a nullity order because securing that official decree triggers the court's jurisdiction to divide property and award financial remedies. A voidable marriage operates on a different set of rules. Section 12 of the Act lists the grounds that make a marriage voidable, but right beneath it, the law introduces the statutory bars under Section 13. Here is the trap. A voidable marriage is fully recognized, legally binding, and valid in the eyes of the state, up until the moment a court explicitly grants a nullity order. Proving that your client meets a ground under Section 12 is only the first step. To actually sever the marriage, your application must survive the strict filtering mechanisms of Section 13. If you fail to navigate these statutory bars, the court will dismiss the application. The applicant remains bound to a flawed marriage, turning a temporary legal defect into an unbreakable life sentence. To dismantle a voidable marriage, we have to map the specific Section 12 grounds against the Section 13 traps designed to block them. This matrix maps Section 12 grounds against Section 13 traps. First, non-consummation. Second, lack of valid consent. Finally, unknown circumstances at the wedding, the respondent having a sexually transmitted infection, an acquired gender, or being pregnant by someone else. Once you establish one of these grounds, you immediately hit the first Section 13 roadblock: delay. The court enforces a strict 3-year rule. Applicants have exactly 3 years from the ceremony to file a petition, locking down claims based on lack of consent, mental disorder, STIs, pregnancy by another, and acquired gender. Miss that deadline and the door shuts. But every family law practitioner must commit one statutory exception to memory. Nullity applications based on non-consummation, whether through incapacity or willful refusal, are immune to the 3-year bar. You can bring these claims decades after the wedding day. Time strictly extinguishes most disputes over a marriage's validity. But the law uniquely forgives delay when a heterosexual marriage suffers from an inherent inability or refusal to be consummated. If you beat the clock, you face the second filter in the Section 13 system, the applicant's knowledge. The rule is absolute. Applications are rejected if you knew about the defect at the altar. This bars claims based on knowing your partner had a sexually transmitted infection, an acquired gender, or was pregnant by another person. However, case law established in Stalker v. Stalker provides a highly specific caveat to that pregnancy rule. The knowledge bar is bypassed if the applicant knew about the pregnancy at the ceremony, but falsely and reasonably believed they were the father. The law refuses to rescue those who walk into defective marriages with eyes wide open. In practice, building these cases relies on tracking down exact evidence of when your client discovered the truth. Even if you file within 3 years and your client had no prior knowledge, the claim can still be destroyed by the final bar, the applicant's own conduct. This is approbation. It prevents annulling a marriage if previous actions signaled acceptance. The test has 2 prongs. First, knowing you had the legal right to annul. Second, behaving in a way that led the respondent to believe you wouldn't. Imagine discovering a lack of valid consent, but choosing to remain in the marital home and merging bank accounts. If both prongs, knowledge of the right and conduct implying acceptance, are met, the court is statutorily barred from granting the decree. Affirmative behavior ratifies a defective marriage. In family law, actions can legally overwrite buyer's remorse, turning a voidable union into a binding contract. What happens when a practitioner successfully proves a Section 12 ground and avoids every Section 13 trap? Look at the timeline of a voidable marriage. When the final nullity order is pronounced, the marriage is severed. But remember, this voidable marriage was 100% legally valid for every single day leading up to that final marker. Because of that validity, the immediate effects are clearly structured. Under the Legitimacy Act 1976, any children born to the parties during the voidable marriage remain fully legitimate. Financially, securing a decree of nullity activates the same property and maintenance powers under the Matrimonial Causes Act 1973 as a standard divorce. The court can order lump sums, property transfers, and pension sharing. Once annulled, the law treats the ex-spouse as if they had died. Any gifts left to them in an existing will automatically lapse. But all of these remedies sit firmly behind the gates of Section 13. Failing to calculate a 3-year time limit, missing the precise timeline of your client's prior knowledge, or ignoring acts of approbation will result in a dismissed application. A voidable marriage is a ticking clock. Mastering the mechanics of the Section 13 statutory bars is the only way a practitioner can prevent a legally flawed union from becoming an inescapable, lifelong obligation.